calling the matter of the state of Wisconsin versus Clyde J. McLemore, 21 CF 181. Appearances, please.
Your Honor, good afternoon. Jim Senf appears for the state as special prosecutor.
Commissioner Keating, this is Attorney Deja Vishny appearing specially on behalf of Mr. McLemore. Mr. McLemore also appears in person.
All right, thank you.
Sorry.
That's okay. I'm sorry. First off, I wanted to ask, good afternoon, but any objection to holding the hearing via the Zoom application from either the state or the defense?
No objection from the state.
None from the defense.
All right, thank you. Then the court will find that not only this hearing, but any subsequent hearing this afternoon, that good cause exists to hold these hearings via the Zoom application, again, based on the coronavirus pandemic, as well as orders previously entered by the Supreme Court for the state of Wisconsin, as well as the Circuit Court for Kenosha County, and further barring any objections raised by defendants and or defendants counsel. All right, thank you very much. Ms. Vishny, on behalf of Mr. McLemore, do you receive a copy of the criminal complaint?
I have received a copy of the criminal complaint, though I had not seen it on e-filing the last time I looked. I had received it in a different way. So I have seen it and I have reviewed it. So I'm prepared to proceed on that basis.
All right, thank you. I do also see a motion that I'll take up following the issue with the complaints. And I'll inquire as to Mr. Sempt, if you received a copy of the motion to seal address as well.
I haven't seen the motion. I was made aware of its existence. I don't have any objection to it.
Okay, well, yeah, let's first take care of, let's deal with the criminal complaint first. So then on behalf of Mr. McLemore, then Ms. Vishny, do you acknowledge receipt of the complaint? Are you requesting a reading, or are you going to waive reading and then have the matter counted for preliminary hearing?
Thank you very much, Your Honor. Yes, at this time we acknowledge receiving the complaint, waive the reading, enter a plea of not guilty to the misdemeanor count subject to jurisdictional objection. We are requesting a preliminary examination. I do wish to advise counsel in the court that I do intend to file some motions prior to the preliminary examination. And because of that, I'm going to request an extension of the normal time limits for the preliminary examination. I would like to hold the preliminary examination during the first half of April.
All right, well, first off, not guilty please with respect to the sole misdemeanor count is noted and entered for the record. Request for preliminary hearing is noted and entered for the record. And I assume then on behalf of Mr. McLemore, Ms. Vishny, you're agreeing to waive time, requesting the court to toll time to calendar the preliminary hearing out beyond the statutory limit?
Yes, I am. Thank you.
All right. Thank you. All right. Thank you. Well, let's address then bond from the state's perspective. Mr. Sempt.
The state recommends a $10,000 signature bond. I'd request as conditions that he not possess any dangerous weapons and that he have no contact with Stephen Winter.
All right. Thank you. I'll also vacate the arrest warrant that had been issued by Judge Wagner on the 19th of this month as well. All right, Ms. Vishny, position on bond, please.
We would have no problem with the bond that's being requested by the state. My only question is, since it's a signature bond and Mr. McLemore isn't physically present, and we're doing this over Zoom, this is the first time we've actually done a first appearance on Zoom, Your Honor. So it's just how the logistics of effectuating that would occur. We don't have any objection to the no contact condition.
I understand. Well, there are two things. The court will decide what type of bail is required or not required. In addition, conditions of bond, normally what occurs is there's an allowance to, if the defendant doesn't wish to sign the bond in person, if usually either counsel or the defendant agree to have the bond document emailed to the defendant or to counsel for the defendant, it has to be then, it cannot be electronically signed simply. It must then be downloaded and then printed out in hard copy, signed with a pen by the defendant, and then scanned back in and submitted or emailed back to the clerk's office within a certain period of time.
Okay.
That's how that process works.
He may be able to come in and sign it. I'm just not sure if he goes to the sheriff's department or, you know, how you handle this in the pandemic. That's all.
The county courthouse is open, just so you're
Okay.
aware. Okay.
So during normal business hours, he can go to the county clerk's, the clerk of court's office to sign it?
Yes.
Okay, I don't think that's going to happen today, but I think it could happen tomorrow if the court will allow that.
That's fine, but let me ask you this. Is there anything you'd like to argue with respect to bond, anything further?
Does the court feel that it needs additional commentary from me?
Yes, I do.
Okay, thank you very much then. So let me just say that Mr. McLemore, the reason I agree with the state's bail request and think it is appropriate is really based on Mr. McLemore's good character and the fact that he will appear in court, which is of course the purpose of bail. I will advise the court that, you know, since the time of this allegation and the issuance of the criminal complaint, obviously, Mr. McLemore was not aware that he would be charged with any criminal offense. Immediately upon learning of it through the media, he immediately took steps to retain counsel. He and I were able to connect by Sunday. I did email your clerk on Sunday evening to schedule this first appearance as soon as possible, and this was the first available time on the court's calendar, which we appreciate. Mr. McLemore resides with his wife, and he has a 17-year-old minor son as well as adult children. He lives really close to Kenosha over the state line. He has had some excellent employment, and I just want to call attention to his most recent job, where he was actually employed as a transition coordinator in the Lake County, Illinois jail. It was a grant-funded position through the Black Chamber of Commerce in Lake County. I did speak with the president of the Black Chamber of Commerce yesterday. I verified Mr. McLemore's employment. It came to an end because the grant funding came to an end. So right now he is collecting unemployment. I'm not sure if the grant will be renewed with the post-COVID programming, but she said he had outstanding performance evaluations. That he's extremely reliable. He was responsible during that 8-month period of helping 150 people transition from jail, not just getting out on bond, but getting housing, getting employment to make sure they didn't recidivate. And of the 150 cases that he managed, only one individual recidivated, which I think is really a very good number. He's obviously had many other jobs, too numerous to mention. I want to bring up that he is involved, a founder and activist with Black Lives Matter in Lake County. They've done some really outstanding work. In particular, I want to draw the court's attention to the fact that they delivered clean drinking water to Flint, Michigan. They rented out a theater and took Black youth to see the movies Black Panther and Harriet, which I think is really outstanding because children, Black children need to be able to see themselves and identify with themselves on the big screen in a very positive way. So he's been involved with children. He has worked with after school programs. He knows somebody who owns a company that produces PPE, and he arranged for $10,000 worth of PPE to be distributed in Lake County, Illinois. So he's engaged in very many positive community service projects. I have no doubt that he will make all of his court appearances and follow the conditions of bail as being requested.
All right, thank you, Ms. Bishny. Mr. Semp, what I'm interested in, obviously, is the purpose of bail is to assure Mr. McLemore's appearance in court. Now, he's a resident of the state of Illinois, which appears to have little or no ties to Kenosha County. Is there any type of record in terms of either failures to appear or some record of conviction or other issue that concerns the state that this court should know about?
I can tell the court that before the appearance today, I did have his record run. I found, well, 1 second.
Judge.
Wait 1 second, ma'am.
Okay, I would like to be heard before Mr. Semp returns. That's all I'm asking.
No, I'm going to take Mr. Semp's position first, and then I'll let you respond to it if you'd like, okay?
Well.
No, wait. When I tell you to wait, you wait.
All right, what I was able to ascertain is that there's a number of arrests on this thing. There are not the number of convictions, and I don't know the timing of some of these. So I'm not comfortable at this point. I mean, this is something that would take some looking into. I'm not comfortable at this time representing that he has certain convictions. But from looking at this document, it appears that there's been a number of arrests and maybe two or three priors, but I haven't been able to confirm that yet.
Well, let me ask you this: arrests. What types of arrests? I'm not going to take into consideration arrests only. Obviously, I'm looking at there's convictions and more specifically failures to appear in court at any of those cases.
Sure. At this time, I'm not aware of any. I'm not comfortable representing that he's missed court based on what I'm looking at.
And these issues here, these arrests, whatever, are they dated or somewhat current?
No, it's a very general. It's just a very general arrest record, Your Honor, or a document indicating that he has been arrested a number of times, and it looks like there's either 2 or 3 convictions. I'm uncomfortable saying more than that.
All right, thank you. Ms. Vishny, you may proceed now.
I just want to let you know that while I don't obviously have access to the document that Mr. Senf has, which was what I was trying to state, because I wanted to be provided with the document before arguing at that, but I have had conversations with Mr. McLemore, and I'm aware that his prior arrests are quite remote in time. In other words, well over 10 years. I'm using that because that's the federal standard, so that he has not had any recent arrests, I believe, at all. So, you know, obviously I don't have the document, so I can't comment on it line by line. But
all right, thank you. I wasn't looking for a comment line by line. All right, thank you. Well, the court is going to impose then a $10,000 signature bond rather than require a cash bail. And the non-monetary conditions, Mr. McLemore, are as follows, sir. You may not, at this point, have any contact, except if it's professional context, with Officer Stephen W. Winter, I believe. You must appear in court here in Kenosha County every time when required, not commit further crimes while you're out on bond, sir. And I'll leave it to you, sir, whether or not you wish to sign that bond in person or have it emailed to you so that you may, but again, you may not just simply electronically sign it. What you need to do is download it, print out the document itself so you have a hard copy, sign it with a pen, scan it, and then email it back. I'll leave it up to you. You choose whether you wish to come to the courthouse is open here in Kenosha County. You go to room 204, that's the second floor clerk's office. And I'll give you some time to do that. And then you would sign the bond in person. It's up to you, sir, whatever you wish to do.
But I have it emailed and then I'll bring it in. Once I have it emailed and then have it read and signed, and then I'll bring it down there to room 204. I bring it tomorrow.
I would just advise the clerk can email it to me, and I will then pass it on to Mr. McLemore. And I'll do that immediately, as soon as I receive it.
All right, that's fine. I guess, Mr. McLemore, if you're going to come up here, you could just simply come up here and sign the bond. Then, I mean, it's up to you. You're going to get a copy of the bond when you sign it. You know, you wouldn't have to go through the effort of printing it out, signing it, bringing it with you, because then you'll have the original bond up here to sign.
Okay, well, I was trying to let my lawyer guide me on this, and we didn't know how this was going to go. So I wanted my lawyer to read.
Judge, Commissioner, what time is the courthouse open until tomorrow?
Till 5 o'clock.
Okay. I think that Mr. McLemore, from what I understand, would be able to get there before 5 p.m. to get it signed. I just didn't know if you closed at 4:30. So I do believe he will get there before 5 p.m. and he can sign that in person tomorrow.
Well, here's the other thing. Otherwise, I could even go out till Friday by, say, 4 p.m. if that makes it easier.
That'd be great. I'm hopeful he'll be able to do it tomorrow.
All right. So, Mr. McLemore, you can come earlier, obviously, if you want. but we'll require you to sign that bond no later than 4 p.m. on Friday, the 26th of February.
Okay.
Make sure you do that, because if you fail to do that, they'll issue a warrant for your arrest, and obviously you wish to avoid that.
Yes, sir.
That will not be happening.
All right, thank you. Now, so will you understand all those conditions, sir, in the bond?
Yes, sir.
All right, thank you, sir. All right, now let's take up this issue of the motion to seal address. Now, I've received the motion, and first off, Ms. Vishny, do you wish to add anything to the motion? I've read it, but I want to make sure, Mr. Semp, have you received and actually reviewed a copy of this motion?
I have not seen it.
Okay. Well, 1 second, please. I want to make sure you receive it before you comment on it, obviously. Do you want to have it emailed to you at this point?
If the court would like me to review it, I'm happy to review it.
I would like you to review something that you're going to have to comment on.
Okay.
Oh, okay. Could we have your email? Might make
Sure.
it easier to email you something.
My email address is james.semf@da.wi.gov.
All right. And then after this, the last thing I'll take up just for council is the issue of tolling time regarding calendaring the preliminary hearing, so that it's my understanding, Ms. Vishny, you're going to request, or on behalf of Mr. McLemore, waive time, request the court to toll time to calendar this preliminary hearing out beyond the 20-day limit. Would that be correct?
That's correct, and I have discussed that with Mr. McLemore, and he's willing to waive the time limits.
All right, thank you. Mr. McLemore, this is the commissioner again. Real quick, sir, you have a right to have a preliminary hearing in a felony case when you're not in custody within 20 days of your initial appearance. You understand?
Sure.
I couldn't hear. You understand that, sir? Okay, thank you, sir. Now, you also have a right to what's called waiving time and requesting the court to toll time so that your preliminary hearing may be scheduled farther out than that 20-day time frame. You understand that as well, sir?
Yes, sir.
All right. Now, your attorney's indicated on your behalf that she discussed that issue with you, and that you were willing to waive time, allow the court, or request the court to toll time for cause in order to calendar your preliminary.
Sure.
All right. Thank you. Then, based on Mr. McLemore's understanding and willingness to waive time, court, and requesting the court to toll time, court will toll time for cause, and indicating that Ms. Vishny intended to file motions on behalf of Mr. McLemore with respect to this matter. So then the court will toll time to allow the preliminary hearing to be calendared farther out than the 20-day statutory limit.
Thank you.
You're welcome. Okay, let me know, Mr. Semp, when you receive that motion and you've had enough time to review it.
Your Honor, I have seen it. I have it now. I did go through it. If I may, I'd like to clarify something I said earlier.
Sure, absolutely.
Okay, just for the court's edification, the court, I had earlier indicated that I didn't have an objection to the motion. I had also said that I had not seen the motion, and so the court may be wondering, well, how do you have no objection to something you haven't seen? I can tell the court that before this appearance, I did discuss the matter with the district attorney, who is not in today, and he indicated that he was aware of the motion. I would assume that he had reviewed it, although he had not said that, and he had informed me that he did not have any objection to it. So my stating I didn't have an objection to it was a direct result of my conversation with him.
Okay, I understand. But now that you've had a chance to review it, does that remain still your position?
It does.
All right, great. Thank you. Ms. Vishny, anything you'd like to add with respect to this motion?
Not if the court does not find that necessary. I think it's pretty straightforward, what I've written.
All right, thank you. All right, I'll grant that motion to seal the address for the reasons stated. Apparently, it's alleged in this motion, and there's no objection to this court entering such an order by the state that there's some threats being to harm Mr. McLemore being made. So Obviously, no one wishes that to occur, and to relieve the burden of that, we can by having this the address of Mr. McLemore sealed. Court will grant that motion.
Thank you very much.
You're welcome.
Preliminary hearing, April the 9th at 10:15.
April 9th?
Correct, yes, it's a Friday. We only do our preliminary hearings in the morning on Tuesday through Friday.
Okay, so I'm just putting it in my calendar, that's all. Preliminary, can you repeat the time, Madam Clerk?
Sure, April 9th at 10:15, so that's good with the defendant for the state?
That's fine. Either myself or DA Wiedenfeld will be at that hearing.
Thank you very much.
All right, thank you very much. And Ms. Vishny, if you could please, if you're going to file these motions like you indicated, could you at least give me, the 5 days needed at least to review those motions before they're brought forth?
Oh, absolutely.
Great, thank you so much. All right, is there anything further from the state's position?
Nothing from me. Thank you.
Thank you. Ms. Vishny, on behalf of Mr. McLemore?
No, I thank you, the court, for its time and consideration.
All right, thank you. Is someone going to prepare that order and then for the court's approval?
The sealing, yes, I can do that, and
All
I'll
right.
e-file it.
Great, thank you very much. All right, that'll conclude the hearing.